So quickly today, what we're going to first start with is amendments to the New York State Human Rights Law. We will talk about changes to salary history inquiries. We will go through the changes to the voting leave laws. And lastly, we'll talk quickly about what the status update is on the legalization of recreational marijuana. That's a topic that's been on the forefront of folks' minds, so I want to give you a quick update as to where things stand with that. So let's first jump into perhaps the largest of all of the changes that have occurred this year, which is with the New York State Human Rights Law. Back in January of 2019, Governor Cuomo signed the GENDA legislation, which stands for Gender Expression Non-Discrimination Act. This law was passed by the Senate and Assembly back in January of 2019. It was signed by Governor Cuomo on January 25th and eventually took effect in February of this year. Generally, GENDA provided additional protections for individuals on the basis of gender identity and gender expression. In addition to the changes to the human rights law, I would quickly note that there are additional provisions that amend New York State's hate law crime and some other laws. I'm not focusing on those here because they don't really impact the workplace, but I did want to mention those quickly. So as I mentioned, GENDA prohibits workplace discrimination on the basis of gender identity or expression. The state has defined gender identity or expression as a person's actual or perceived gender-related identity, appearance, behavior, expression, or other gender-related characteristic regardless of the sex assigned to that person at birth. It includes, but is not limited to, the status of one being transgender. This might not be new for many of you because back in 2016, the New York State Division of Human Rights issued regulations which indicated that gender identity, gender expression, and transgender status were protected under the New York State Human Rights Law. So many of us have been living with this for quite some time. That being said, the importance of GENDA is the fact that the legislature and Governor Cuomo actually passed these changes into law. So it's now law, not just regulatory guidance from the New York State Division of Human Rights. So some things to keep in mind in light of GENDA. If you haven't already done so, you should be sure to go back into any EEO policies and ensure to add gender identity and gender expression as a protected class. To the extent you are doing any training on non-discrimination or non-harassment laws, be sure to incorporate gender identity and gender expression issues into that training. If you have an employee who identifies as transgender or has a gender identity or gender expression that they prefer to use a different pronoun than the one potentially assigned to them at birth, allow an employee to choose the pronoun of their preference. You may also consider allowing latitude in any dress and grooming policy. Be mindful of information privacy. So if you are aware that an employee, for example, identifies as transgender and that person may be transitioning, please be aware that that information should be kept confidential. If an employee has asked that their employment documents be changed to a different name, you should not require a court order for such name change where the requested change is related to someone's gender identity or gender expression. In July of 2012, New York State went into effect in New York State the amended definition of race. So the human rights law definition of race was amended to include traits historically associated with race, including but not limited to hair texture and protective hairstyles. Protective hairstyles typically includes braids, dreadlocks, or other twists. Please note that the braids, locks, and hair twists are just a few examples of protective hairstyles that may be captured under this new definition of race. Shortly after New York expanded its definition of race to include historically associated traits. The state also passed in July, effective, however, October 8th, 2019, expanded religious protections. These protections prohibit employers from discriminating against an individual for wearing any attire, clothing, or facial hair which is required by that person's sincerely held religious belief. This applies, as just a few examples, to clothing such as turbans, headscarves, hijabs, burqas, yarmulkes, and beards. Just for some context as to the history of the passage of this piece of legislation, there was an MTA employee who wore a turban as part of his religion. The MTA initially asked that the employee no longer wear the turban, but wear an MTA hat instead. As a religious accommodation, the employee asked that he be allowed to continue to wear his turban. The MTA then asked that the employee put the MTA logo on the turban so that customers and other passengers on the MTA could identify that person as an MTA employee. This legislation is meant to deal with that issue, and an employer is prohibited from requiring an employee to attach a company logo to any religious attire that they may be wearing as part of a sincerely held religious belief. It's unclear if the statute extends to things such as jewelry, body piercings, or even tattoos that have religious significance. As with other religious accommodation requests, the state is applying an undue hardship test. What that means is that if an employee has asked as a religious accommodation to wear a particular piece of clothing, then the employer has to go through the undue hardship test to determine whether or not the employer cannot accommodate that test. Generally speaking, the undue hardship test that is applied in the religious context is a lesser standard than the one we typically talk about when dealing with the ADA or disabilities under the human rights law. But nevertheless, if you do have a situation where an employee is asked for an accommodation concerning attire or concerning their religious belief, it's usually helpful to get in touch with your labor council to walk through those issues. So some quick takeaways on the protection, the expanded definition of race and the protection of racial traits as well as the religious attire. Again, review your policies and procedures to the extent that you are already making changes. You may also want to consider adding traits historically associated with race as part of your definition in your EEO policy. If you have a dress code or a grooming policy, you want to review that and make sure that there's nothing in there that prohibits certain types of hairstyles that may be impacted by the changed definition of race, or may impact an employee's ability to wear religious attire that is worn in conjunction with someone's sincerely held religious belief. You may also want to review your policies and consider adding or addressing a reasonable accommodation of policy as it pertains to religious practices. And then lastly, and this will be a theme throughout the presentation today, make sure that you train your supervisors, your floor staff, any hiring staff with regard to these new changes. So now if we move on to the biggie, which is some of the changes to the harassment amendments, I first want to go back and talk a little bit about what happened back in 2018. So many of you on this webinar probably remember that about this time last year in 2018, the state had passed a series of changes which really became known as the sexual harassment changes. Those changes limited our ability to utilize confidentiality provisions in various employment agreements. It prohibited the use of arbitration agreements to resolve sexual harassment claims. It extended protection, sexual harassment protection, to non-employees who are in the workplace. It provided for a mandatory policy as well as mandatory training, and there were some other requirements as well. However, those changes really focused on sexual harassment. Fast forward about a year, and in 2019, primarily through the summer of 2019, the legislature passed a series of additional changes to the human rights law dealing with harassment and discrimination. I first want to talk about the scope and coverage remedies. Because some of these various changes were either passed at different times or have different effective dates, I thought it was helpful for these initial topics to put in a chart so that you could see how the effective dates are different in a number of these areas. So just keep in mind that as I go through these changes, all of the changes apply on a go forward basis, which means that they will only apply to claims that are filed after the effective date. So if we first start with the definition of employer. The state passed a change to the human rights law which expanded the definition of who an employer is under the human rights law. So you may remember that prior to this change, employers with 4 or more employees were the only employers subject to the New York State human rights law. Prior to this year, that was the case for all forms of discrimination with the exception of sexual harassment. That was a change last year. Under the new changes, all employers, regardless of size and regardless of the protected category, are covered by the New York State human rights law. The effective date for that change is February 8th, 2020, so we've not yet gotten there, but keep that in mind as we go through the first quarter. The next change, the old law was that punitive damages were not available under the New York State human rights law, which was an incentive for many folks to go, if they were so inclined to file a charge or file a lawsuit, to file that lawsuit in federal court because Title VII provides for punitive damages. That has now gone away as of October 11th, 2019, so it's already in effect. Any claim that is filed after October 11th of this year, punitive damages may be available for a successful plaintiff, and those damages are not capped like they are under federal law. Attorney's fees prior to this year were only possibly available in sex discrimination cases as of October 11th of 2019. So again, just a couple weeks ago. And for all claims having been filed after October 11th, attorney's fees will be awarded automatically for any prevailing party who's brought an employment discrimination claim. However, please be aware that while employers may be able to receive attorney's fees if the employer is the prevailing party in the case, the exception to that is the employer has to prove that the claim was frivolous. And if you're in the State Division of Human Rights, there's been an administrative charge. You can only try and get attorney's fees if you prevail as the employer after the hearing. So if you go through an investigation and the division finds that there is no probable cause to find that any discrimination occurred, you as the employer would not, even though you've prevailed at that stage of the investigation, you would not be able to recover attorney's fees at that point. You would have to get a probable cause determination, go through the hearing, and also prove that the employee's case was frivolous. The deadline to file a complaint with the Division of Human Rights has also been extended, but only for claims of sexual harassment. So just as a quick refresher, prior to this year, for all claims, you had 1 year to file a complaint with the State Division of Human Rights if you wanted to go the administrative route, or you as a plaintiff could choose to go directly to state court, and you would have 3 years to do that. Again, regardless of what the claim of employment discrimination was. Now, for only sexual harassment claims and beginning August 12th of 2020, you have 3 years to file a sexual harassment claim either in state court or with the Division of Human Rights. So this is one of the few areas where we are only focused on sexual harassment, and the statute of limitations has been extended with regard to filing a claim with the Division of Human Rights. And again, this change applies only to any claims filed after the effective date. So again, we're looking at August 12th, 2020. Sorry. Oh, no, it's working. Last year, you may recall that New York State was, the New York State Human Rights Law was expanded to provide protection to non-employees in the workplace or non-employees with whom your own employees had interactions with throughout the course of their work. Effective October 11th, 2019, so again, we're already in effect. The human rights law will protect contractors, vendors, consultants, and others providing services in the workplace pursuant to a contract from all forms of discrimination and harassment. So again, last year, this protection applied only to non-employees if there were issues of sexual harassment. Now, non-employees are protected from all forms of harassment and discrimination if they come into contact with your employees. The test here in determining whether or not an employee may be liable to a non-employee is if the employer knew or should have known about the conduct and the non-employee was subject to discriminatory practices, but the employer failed to take immediate corrective action to address that issue. Last year, as I mentioned at the outset, New York State prohibited the use of arbitration clauses to be used in the sexual harassment context. So what that meant was that any employer who had an arbitration agreement with an employee whereby that employee agreed to take any disputes he or she had with the employer to arbitration, the state said, no, those types of provisions are no longer lawful. Again, that prohibition was applied only to sexual harassment claims. That meant if an employee had an allegation of age discrimination, race discrimination, whatever the case may be, if it did not deal with sexual harassment, the employer could enforce that arbitration agreement and require the employee to take that claim to arbitration. Effective October 11th, 2019, so again, it's in place now. Those arbitration prohibitions have been extended to any and all discrimination claims. Now, these changes really come with a big caveat. Earlier this year, and as we talked about these issues late last year, there was an outstanding question as to whether or not the state law prohibiting arbitration in any particular context would be preempted by the Federal Arbitration Act. There's been a district court, a judge down in the Southern District of New York, who has found that the Federal Arbitration Act preempts the New York State prohibition on arbitration clauses. What that means is that an employer would be able to go to court and enforce the arbitration clause even where there's a claim of workplace harassment. And the argument would be that the New York State law does not apply because it's preempted by federal law, and federal law says that arbitration agreements should be enforced, and there's an overwhelming support of enforcement of arbitration agreements. But the inquiry really doesn't end there, and the reason is there's only been one district court that has ruled on this case, or on this issue. It's down in the Southern District of New York. There's 5 other districts in the Second Circuit which have not addressed this issue. So until we get a ruling out of the Western District of New York, if you're in Western New York, the Northern District of New York, Eastern District, or the District of Vermont. Depending on where you're situated, the Southern District case may not be controlling. That being said, it is probably persuasive, but until the Second Circuit makes a decision, we won't have a clear-cut answer on this. So keep in mind that the state has prohibited the use of arbitration clauses to be enforced against discrimination claims, but the ultimate, whether ultimately that state law will be upheld is still in flux. So anyone who has entered into any type of settlement agreement over the past course of the past year concerning a claim of sexual harassment knows that we can no longer just as of right or automatically contain a confidentiality provision in a settlement agreement. The old law, or which is the current law, which applied to sexual harassment claims, provided that there could not be any confidentiality provisions in an agreement which prohibited the employee from disclosing the underlying facts or circumstances of a sexual harassment claim unless there were certain factors that were met. The confidentiality clause had to be the complainant's preference. There had to be a full 21 days for that person, that charging party or that claimant to consider the confidentiality provision. They still had 7 days to revoke that confidentiality provision. So what that meant was that we had to have a separate agreement which showed that the complainant had a preference to include that confidentiality provision in the main agreement. We had to give 21 days for that to be considered and then 7 days to revoke. And then obviously you had to have the secondary agreement or the main agreement which contained the confidentiality provision that the employee indicated that, or former employee indicated that they were okay with, and that was their preference. Despite these prohibitions on confidentiality with regard to the underlying circumstances or facts of the sexual harassment claim, it has been the case, and it was the case, it still is the case, that the settlement amount could be required to be kept confidential. So if you have a situation where you're either entering into a separation agreement or a severance agreement, have discussions with your labor counsel about what the limits of confidentiality can be, and if you can still limit the confidentiality of the amount, or if you want to go further than that. Effective October 11th, 2019, these non-disclosure prohibitions were expanded to include all forms of discrimination, not just sexual harassment. So again, the factors that we just talked about, or the steps that we just talked about, including the 21-day time to consider, 7 days to revoke, and having the separate memorandum of agreement indicating that it's the employee's preference, are now in place for all forms of discrimination claims. So if you are either settling a claim of discrimination, you are dealing with a separation agreement or severance agreement, make sure that you are sensitive to these issues, especially if there's been a situation where an employee has threatened or made a complaint of any type of discrimination in the workplace. In addition, it's important to note that any confidentiality provision, in addition to which may limit the discussion of underlying facts and circumstances, cannot limit subpoena-related activity, which either means initiating, testifying, assisting, or complying with a subpoena from a government agency, which would include a court. It would include the EEOC or the New York State Division of Human Rights. It also cannot prohibit an employee from cooperating or participating with a government agency, including the EEOC or the State Division of Human Rights. And lastly, any confidentiality provision cannot limit the filing or disclosure of information which relates to any claim for unemployment insurance, Medicaid, or other public benefit claim. Additionally, and these are really best practices, although now they've been put into the New York State Human Rights Law statute. but it requires the confidentiality non-disclosure clauses to be written in plain English, and it has to be written in the primary language of the complainant or the plaintiff if applicable, if the person is a non-English speaker or if the person has English as their second language. The provision also cannot bar the disclosure of facts of any future discrimination claims unless it expressly excludes the disclosure to law enforcement, EEOC, the Division of Human Rights, or any other local commission on human rights, for example, the New York State Human Rights Commission, or the employee's attorney. These changes apply for all contracts entered into on or after January 1st, 2020. Again, keep in mind, however, that despite all of this, we can keep the settlement amount confidential. So last year, as I mentioned at the outset, the 2018 sexual harassment changes required that we give employees a sexual harassment prevention policy in writing, and that policy had to be compliant with the new New York State standards. Now, effective August 12th, 2019, the policy must be provided at the time of hiring as well as at every annual training program. So that's different than what we knew last year. It's unclear what it means to have to provide the training at every annual training program, if that means you have to hand out a physical copy for employees to keep, or if it's sufficient to direct employees as to where to locate the policy on the employer's intranet page or within HR, or whether or not it's sufficient if you go through the substance of that harassment policy at the time of the training. In addition, another new change is that the policy has to be provided in English as well as any other primary language of the employees. If you just simply adopted the state's model policy last year, the state has put out a number of model policies in a variety of languages, so you would be able to pull that off the state's website. Also keep in mind that you're only required to translate the policy into the languages of those languages that the state has translated theirs into. So if you go on the website, you'll see that you'll see the languages that the state has translated the model policy into. If, however, you did not adopt the model policy and you utilized your own policy, which is compliant, just know that if an employee is a non-English speaker, that you will have to find a translation service to translate that policy for them. It's also unclear, although it's our understanding, that these changes appear to apply only to policies, but not necessarily to the training requirements. But that doesn't mean that there aren't other changes to the sexual harassment training requirements. So beginning in October of 2018 and up until August 12th of 2019, employers have to give annualized sexual harassment training. Now, in addition to giving that annual training, employers also must give employees the information which was presented at the sexual harassment training, and it must be provided in English and any other primary language of the employee. If you are interested in training services, we do provide both live training as well as online interactive training if you're looking for training for this next round of to meet your annual requirement. So one of the more notable changes in this latest round is the lower harassment burden for employees under the New York State human rights law. So prior to October 11th, 2019, the standard in New York State was the same as the standard under federal law, which was that if an employee brought a harassment claim, they had to prove that the conduct was severe or pervasive. If you recall, there are about 4 elements for an employee to prove unlawful, hostile work environment harassment. It has to be on the basis of a protected category. It has to be severe or pervasive. It has to be unwanted. And it has to rise to the level of altering one's terms and conditions of employment. So this amendment changes that element that requires an employee to show that the conduct was severe and pervasive. Either that it was one instance was so severe that it altered conditions, or that there was a pattern of conduct. Under the new law, under the new changes, an employee only has to show that the conduct subjects that person to inferior terms, conditions, or privileges of employment, and it is beyond a petty slight or a trivial inconvenience. This is arguably a much broader standard than what we were dealing with previously under the severe and pervasive test. In addition, while there is this, the test now is that the person is subjected to inferior terms and conditions of employment, the employee or the plaintiff, the complaining party, does not have to necessarily provide comparator evidence. That is, they don't necessarily need to explicitly identify other individuals who are treated better than they were. Over the series of the next few slides, we'll talk a little bit more about what exactly the standard means. But before we get to that, I do want to first address, okay, so what are our defenses now as an employer? Well, even if an employee is able to show that they were subject to a hostile work environment, meaning they're able to show that the conduct was based on a protected category, it was unwanted, their terms and conditions were inferior to others, and it created an abusive environment. An employer is only liable for that conduct if the employee was encouraging it, condoning it, or approving it. So employers still have an affirmative defense to show that they did not encourage, condone, or approve the conduct that the employee was exposed to. In addition to that, it is a limited affirmative defense for an employer to say the conduct that they were exposed to. So if the employee attempts to show that they were subjected to inferior terms and conditions of employment, the employer can assert an affirmative defense to say that those inferior terms and conditions of employment were merely petty slights and trivial inconveniences, and therefore they are not actionable. What's important to remember about this is that because it's an affirmative defense, the employer has the burden to show that the conduct was a petty slight or a trivial inconvenience. That might be a small comfort, but it's there. Again, this change is already in effect. It went into effect October 11th, 2019. So let's go through a few examples of what less well treatment looks like. So while this has not been the standard under the New York State human rights law, the New York City Commission on Human Rights changed its ordinance a number of years ago, approximately 6 or more years ago, to adopt this inferior terms and conditions test with the affirmative defense that the conduct was a petty slight or trivial inconvenience. So while we don't necessarily know entirely how these cases will be decided, we can look at how the New York City law has been interpreted to give us some guidance as to how we think this standard may be implemented on a go-forward basis. So examples of less well treatment that a court found met the definition or met that standard of less well treatment. A CEO told a female employee that she needed to respect male employees because of their more powerful status over women. And when male employees routinely rated the appearance of female employees and openly discussed trips to strip clubs. So that's a fact pattern where a court said, yes, that is less well treatment, and the conduct would be actionable so long as it met those other elements. Another court found that this conduct would be considered less well treatment and therefore met that element of the test. A supervisor made sexual gestures to a female employee, repeatedly informed her that he wanted to hug her, and commented on her body and expressed a romantic attention in her, invited her to his home. Again, that is conduct that would rise to the level of that less well treatment and may be actionable. A supervisor regularly commented that an employee's age made him slow, lazy, and incompetent. So again, it's important to realize and to know that this standard applies across the board, not just to sexual harassment claims. Coworkers spread a rumor about a female employee attending a meeting without a bra, and supervisors failed to address the employees who spread those rumors. So again, those are all examples of conduct that would meet the less well standard. Transitioning to some examples where the employer met their affirmative defense to show that the conduct was really nothing more than a petty slight or a trivial inconvenience. A male supervisor summoned a female employee to his office and opened the door shirtless. While I wouldn't encourage anyone to do that, the court found that the employer met their affirmative defense, that that type of conduct was a petty slight or a trivial inconvenience. A male supervisor telling a female employee that she should consider getting breast implants. Again, a court found that that was a petty slight and trivial inconvenience, and the employer met their affirmative defense. Another court found that telling a Colombian employee that she did not belong here and needed to go back to Colombia, the employer met their affirmative defense that that was a petty slight and trivial inconvenience. And then finally, a supervisor calling his female assistant my bitch and commenting that her boobs are always popping out and she's wearing a thong today. Again, the employer met their affirmative defense that that was nothing more than a petty slight or trivial inconvenience. Now, I will say that there seems to be some inconsistency on how the courts have come down on some of these issues, and some of the examples that I just went through where the court found that it was a petty slight or trivial inconvenience was not the outcome I would have necessarily would have guessed. So keep in mind that this is really an ongoing and changing area of the law, and we don't really have a lot of great guidance as to where courts will come down on these issues. Also keep in mind that it will be more than just courts deciding these issues, as if an employee or a former employee takes a complaint to the Division of Human Rights, you'll have an administrative law judge at the Division of Human Rights determining what constitutes a petty slight or trivial inconvenience. And that may not be the same as what a court may find. So quickly going through some practical recommendations in light of all of the changes we just went through, you'll want to make sure that you revise any mandatory sexual harassment training program and policy as needed in light of the changes we just went through. As a best practice, you will probably want to consider having separate training for your supervisors and managers, particularly so that you can go in more depth to talk about the changing standard, what constitutes a petty slight, trivial inconvenience, so that they really understand what the consequences are of not taking immediate action on these issues. If you have not already had to do so, obtain translations of your sexual harassment training policy materials, training and policy materials. Review any existing agreements that you have in place to ensure that you're not running afoul of the prohibition on use of arbitration agreements or on confidentiality and non-disclosure provisions. The other note I will make on this is if you are also thinking about including a non-disclosure provision, or I'm sorry, a non-disparagement provision, make sure to have a conversation with your attorney about what the consequences of that are and whether or not we can include a non-disparagement clause in light of the prohibition on the confidentiality provisions. You'll want to make sure that you educate your leadership about these significant changes, in particular, the new lower threshold for harassment claims. Make sure that your executive leadership understands the financial consequences of not taking action, in particular, now that punitive damages are on the table, attorney's fees are on the table. These claims, these types of claims are going to now be much more expensive. You'll want to make sure that you create or review your investigatory procedures and plans. Again, you'll need to make sure that it's compliant with the New York State training model policy requirements, and make sure that you have reviewed and know what your investigatory process is. If you have a process that you don't follow when you have a complaint, that can lead to more issues than it does solve problems. Make sure that any complaint that is brought to you, whether it's formal or informal, make sure everything is documented, make sure that we follow our investigation procedure, and make sure that we document any corrective action that we ultimately take. And lastly, we really want to make sure that we are cultivating a culture of respectfulness. So that is a top-down initiative that can be done outside of any of the training and policy requirements, and really make sure that you're encouraging everyone to be respectful of each other. I want to talk quickly about some changes to the protections for domestic violence victims. Domestic violence victims have always been a protected class, but there have been some additional changes and protections for those individuals effective November 18th, 2019. Employers must permit victims of domestic violence to take reasonable time off of work for a series of reasons. It can be to seek medical attention for themselves or their child, obtain services from a shelter program, obtain counseling, participate in safety program, act to increase safety from future incidents, or appear in court or assist in the prosecution of domestic violence offenses. Previously, domestic violence victims had to be given time off to appear in court, but that's now been extended. There is a undue hardship exception, but we have to take into account the size of the employer, the type of operation of the employer, and really what the impact is of that person's time off of work for any of the reasons I just mentioned. An employer may require an employee to use any paid time off unless there are other requirements in a collective bargaining agreement or written policy. If someone does not have PTO left, or they've used up all of their time, any further time off would have to be unpaid. Also keep in mind that a leave of absence related to a domestic violence reason, the employer would have to keep their health insurance going during that time. An employee who is seeking to take time off of work for any one of the reasons I mentioned has to provide reasonable advance notice if it's feasible. If it's not feasible, the employer can ask for certification from the employee. Any information that the employer receives concerning someone's status as a domestic violence victim, or any information concerning a pending court case or anything like that, all of that has to be kept confidential. So some takeaways with regard to this, just as a refresher, domestic violence victims are a protected class of individuals. Make sure that there may be other legal issues for individuals taking time off related to disability, paid family leave, and FMLA. So make sure all of your policies coincide. So take a look at your handbook on that. You may want to consider updating or creating an accommodations policy as it applies to domestic violence policy or domestic violence victims. And lastly, again, train supervisors and managers on these issues. So switching quickly to salary history inquiries. Effective January 6th, 2020, New York employers will not be able to require an employee or an applicant to disclose what their salary history is, either on their employment application or throughout the application or hiring process. So an employer also cannot rely on wage history of an applicant to determine whether or not to offer employment to that applicant. An employer cannot retaliate against an employee or an applicant if they refuse to provide their salary history. And employers are also prohibited from refusing to interview, hire, promote any employee or applicant based on their prior wage history. This applies to employers regardless of size, but in addition, please note that an applicant or an employee is not prohibited from voluntarily disclosing wage history, although it's really anticipated that if that history is disclosed, it's for the purpose of negotiation. Employers, however, if an employee is using their wage history to negotiate a higher starting wage or salary, employers may ask for verification of that history after those negotiations have been done or have begun. Some quick takeaways here: make sure that there are no questions on your employment applications concerning salary history, or if you have any other pre-employment forms, make sure that none of those ask for prior salary history. Again, you need to train any personnel who are conducting interviews, and you'll want to make sure that all of your supervisors and managers are trained on this, especially if they're involved in discussions about starting wages and salary. So next, I'll quickly go through the voting leave law changes because we're running out of time here. So generally, the former election law, section 3-1110 required registered voters, if they did not have sufficient time outside of work, to be provided time off of work without a loss of pay for up to 2 hours to vote. That law has changed. I'm not going to read it right now because I want to go through the specific changes so you can see what the specific changes are comparing them. So there's no more 4-hour presumption. So I skipped over. So everyone has up to 3 hours to vote, regardless of whether or not that person has some time before or after work to vote. So the new change provides that a registered voter may, without loss of pay for up to 3 hours, take off so much working time as enable that employee to vote at any election. So what this means is that the voting leave is available to both full-time and part-time employees. To receive time off, an employee, however, must be scheduled to work on election day. If an employee is on the schedule for election day, the number of scheduled hours does not matter. That employee has to be given, without loss of pay, up to 3 hours to vote. There's no longer a 4-hour presumption. What that means is that the employee shall be allowed time off for voting only at the beginning or end of his or her working shift, as the employee may designate unless mutually agreed. So it doesn't matter if that person's shift starts 4 hours after polls open or ends 4 hours before polls close. Employees are technically only entitled to take off so much time, so much working time as will enable them to vote. However, if we begin asking questions and ask that the employee provide proof of how much time it actually took the employee to vote, you do run the risk of violating the law if we don't provide the full 3 hours that's provided for in the statute. Employees, so it used to be that employees had to provide at least anywhere between 2 to 10 days notice of the need for working time off to vote. That has changed, so now the employee is required, if the employee requires working time off to vote, the employee shall notify his or her employer not less than 2 working days before the day of the election that he or she requires time off to vote. That means, obviously, that employees will be providing much less notice than they may have before. Please note that employers are required to post a notice 10 working days before every election that sets forth what the requirements of the voting leave law are. So if you haven't already posted it, election day is November 3rd, so you better get it up. The form notice is available at that website on the slide. You need to post that notice conspicuously in the place of work where it can be seen as employees come or go. And the notice has to stay up until after the polls close on election day. So what does election day mean? What elections qualify? Well, it includes the primary and general elections, as well as any special elections called for the governor. It does not include early voting periods. We just went through that yesterday. It does not include those types of periods. And it also does not include school district elections, library district elections, fire district elections, or special town elections. You may be wondering if you can ask for proof if someone is either a registered voter or actually voting. The law does not discuss whether or not an employer can ask for proof that they are either a registered voter or have actually voted. The purpose of the law and the guidance from the Board of Elections really is indicating conflicting views. So on the one hand, the Board of Election has pointed to the New York Civil Service guidance that state employees should not be asked for proof of voter registration or actual voting by employees. But the board also notes that election workers are not responsible for providing documentation to voters to verify that that person voted. That being said, the entire purpose of the law is to give somebody time off for the purpose of voting. So it's unclear as to whether or not employers can ask for proof, or really what the consequences would be if an employee fails to provide that proof. Can employees be required to use PTO? The answer to this is no. The statute provides that employees have to be given up to 3 hours of voting leave without loss of pay. There's a very strong argument that somebody using paid time off, vacation, whatever the case may be, is losing pay because they're losing that accrued time. What if an employer doesn't comply? Well, an employee does have a private right of action for any unpaid wages. So if you give the employee 3 hours of unpaid time off, they would have the right to collect that 3 hours of paid time. There's also misdemeanor criminal charges which can apply in instances where the employer knowingly and willfully violated the law. So I quickly want to just provide an update on the legalization of recreational marijuana, really for no other reason than this is a question that comes up a lot. And at this point, we're looking at a crystal ball, but I want to let you know where we stand. So just quickly, there are a number of national trends on both the medical side as well as the recreational side. Over half of the states have adopted medical marijuana statutes that allow for the use of medical marijuana to care for certain medical conditions. On the recreational side of things, the trends are lesser. There are approximately 10 states that have legalized the use of marijuana recreationally, along with DC and Canada. 13 more states have decriminalized lower levels of possession. New York is one of those states. Just quickly, obviously there's been a big shift over people's perceptions and tolerance over the legalization of recreational marijuana. The governor himself, as of 2017, said marijuana is a gateway drug. It leads to the use of other drugs. And there's a lot of proof that that's true. And at the time, the governor was against the legalization of recreational marijuana. You may also recall that he was also opposed to the use of medicinal marijuana for a long time prior to the Compassionate Care Act in 2014. As of the end of 2018, Governor Cuomo had changed his tune a bit and had come across or come around to, yes, let's legalize the adult use of recreational marijuana once and for all. Part of this may be because of the economic data that has come out of the economic impact that the legalization of recreational marijuana may have. So nationally, the legal cannabis market is estimated at $7.2 billion in 2016. So again, that was 2 years ago. Nationally, there was a projected growth of approximately 17% annually. Recreational sales nationally are projected at $11.2 billion by 2020. So in New York State, there are some estimates, some reports that are out there that indicate that the legalization of recreational marijuana could generate $300 million in new state revenue and create a $3.1 billion market. So obviously money talks, which may very well be the driving force for the push for the legalization of recreational marijuana. But as many of you may recall, back in the springtime frame, the recreational use of marijuana failed to be passed as part of the legislative session. And it has also failed to be included in next year's budget bill. What that means is that it doesn't look like there will be legalization of recreational marijuana for at least the next year or so. New York, as I mentioned, has decriminalized the use of or the possession of less than 2 ounces of marijuana. It's now only a violation, which is akin to pretty much a traffic ticket. That means there's a fine, but no criminal charges. So at the end of the day, using marijuana is still unlawful if it's for recreational purposes or you do not have a prescription for it. So in light of our time, I will just very quickly go through the Compassionate Care Act. Just as a quick reminder, the Compassionate Care Act back in 2014 legalized and regulated the manufacture, sale, and use of medical marijuana in New York. There are only, to be eligible, a patient must have a certified condition and be seen by a CCA registered physician, and they must have a condition that is set forth within the statute. That condition has to be severe, debilitating, or life-threatening, and accompanied by a qualifying or complicating condition. The patient must get any medical marijuana from a licensed dispensary to be protected. So quick takeaways on the medical marijuana side of things. Require employees to identify whether they are on any medication which could impair their performance or judgment. Disability-related inquiries are lawful if it's job-related and consistent with business necessity. This is especially important for safety-sensitive positions. You want to consider adopting a drug testing program, especially, again, for safety-sensitive positions. Think about how you handle pre-employment, reasonable suspicion, and random drug testing, and how you want that program to look. You'll need to be prepared to offer reasonable accommodation for an employee who has been prescribed medical marijuana and is using that and qualifies under the protections of the Compassionate Care Act. This may include eliminating certain tangent functions, allowing for a leave of absence, or reassigning them to a vacant position. You also want to think about reviewing and revising your job descriptions, training supervisors and managers to identify document impairment, because employees are not protected to show up for work impaired. And you may want to think about other ways or how you gather that evidence and how you document it. You want to think about training your staff, your supervisors, in addition to, again, looking for impairment. Think about, they need to know what to do if there is a positive drug test, and how you handle those aspects. So just as the last takeaway, I will continue to track the legal status of recreational marijuana and make sure that you have all of your bases covered in instances where you have an employee who has been prescribed medical marijuana. And with that, if there have been any questions throughout the course of the presentation, I will take a look at those that have been submitted. It looks like there have been a few, and be sure to follow up with those folks who submitted questions. Thank you.